your client is literally sitting in the dark and she got her phone up, and I'm getting offended, and I want her to stop. Like, I want her to stop. So she's sitting in the dark, she's on her phone. Ma'am, don't do that to me. I don't know who you think. Let me tell you something. You got the right one today. You have the right one today. And if we were in person, if everybody was in person and not just Ms. Benson, I could see how this situation would have gotten out of control, and my courtroom would probably be full right now with 2, 3, 4, and 5 officers. Because there's not gonna ever be a day. There's never gonna be a day when I'm gonna come to work and not be in charge of my courtroom. And y'all need to mute the courtroom, because if she says something going out, she's gonna get those 5 days. Versus Toya Lamar Mayberry. The defendant is charged with 1 count of assault aggravated. Today is the date set for sentencing. Appearances, please.
Good morning, Your Honor. Christina Ritter on behalf of the people. P number 83505. The complaining witness is in person in the courtroom. Mr. Williams, can you state your name for the record, please?
Steve Williams.
And Clay Miller, Your Honor, PA 6291, standing in for Attorney Potts on this matter, here on behalf of Mr. Mayberry. Mr. Mayberry, please state your name for the record.
Clay Mayberry.
Mr. Mayberry, what's your name?
Toya Lamar Mayberry Jr.
Thank you. Today is the date set for sentencing. However, Judge Garrett did not order a pre-sentence investigation for Mr. Mayberry, and on an assault aggravated case, I need a pre-sentence investigation. I don't want to do the sentencing without, because that would, it's a 1-year misdemeanor, and I need a pre-sentence investigation so I can see what I'm working with and know which way to go with the sentencing. Now, the complaining witness is present, and I don't know if the complaining witness had intended to make a victim impact statement, if they are going to be, if they wanted to make a victim impact statement and they're going to be unable to come on the new date that I'm going to give, I will allow them to make a victim impact statement today, but I'm not going to sentence today. So would there be any objection to me doing it in that way? Mr. Mayberry, take your hand down for me, please. Would there be any objection with me doing it that way?
Not from the people, Judge.
None from us, Judge, either. So whatever the court wants.
Okay, so they asked for at least 4 weeks to complete the pre-sentence investigation process. So I would be scheduling it, looks like February the 12th. Give them the 4 weeks to do that. Is that a good day for your office, Mr. Miller?
Let me double check, but it should be fine. Monday, February 12th. That'll work. That'll work.
Okay. And then I apologize, Ms. Ritter. What was your witness's last name?
Williams.
Okay. And then Mr. Williams, let me ask you first, Ms. Ritter. What did your witness intend to make a victim impact statement?
I'll defer to Mr. Williams, Judge.
All right, Mr. Williams, was it your intention to make a victim impact statement to the court?
Yes.
Okay, and then I'm going to adjourn the sentencing because the judge that took the plea in my absence didn't order a pre-sentence investigation. So I'm going to adjourn the sentencing to February the 12th. Did you want to appear that day to make your victim impact statement, or do you want to go ahead and make a victim impact statement today?
I would like to make a statement today, and I will also be here February 12th. But I want to make my statement today.
Can I tell you something?
Yes.
Okay, so if you're gonna be here February the 12th, I personally prefer for you to make the statement on the 12th so that the statement, if it's going to impact my sentence in any way, I'll have your statement with the pre-sentence report. Now, because I was giving you the opportunity to make the victim impact statement today if you couldn't come on the 12th, but the Victims' Rights Act, it says you have a right to make a statement at the time of sentencing. So I would prefer you, if you're going to come on the 12th, I would prefer you wait until the 12th to give me your statement. Also, probation is going to contact you as well when they are doing their pre-sentence investigation. Probation is going to contact you also. So you can give a statement to them. You can give them a verbal statement. You can give them a written statement. If you want it included in the pre-sentence report, and then I would read it, in advance. And then you can also still give a verbal victim impact statement when you come to court.
Well, Your Honor, there's no guarantee I might not make it to court February 12th. This is why I've been coming every court day.
Okay.
So
I mean, there's no guarantee that any of us is gonna make it, but I'm gonna go ahead and let you make your statement. And then, but understand, so I guess I want to be clear. I'm gonna go ahead and let you make the statement today, but that means on the 12th, you cannot make a verbal victim impact statement. You don't get to make two verbal victim impact statements. You understand?
I understand.
Okay, then, with no objection from the defense, the court is going to allow Mr. Williams to make his victim impact statement today. Mr. Williams, you may proceed.
Well, Your Honor, February 24th, 2023, I was attacked and assaulted inside of a funeral home. And I was beaten with brass knuckles. And I have the pictures taken from the hospital of my face by my nephews and my niece. If you would like to see the pictures.
No, sir, I don't want to see the pictures today, but you can forward them to the prosecutor's office and she will make sure that I get them. In fact, it looks like you're in person today. I didn't mean to say that. It looks like you have them with you today. Are they in color? Are those pictures in color?
Yes, they are.
Okay, so if you want to leave those pictures with my clerk, he will put them in an envelope and give them to the prosecutor's office. So she will make sure that I get them, or they can make a copy of them, and then she'll make sure that I get them. If you want me to see the color photos, though, you're gonna have to leave the pictures that you have or email them or something to the prosecutor. So you can go ahead.
Okay, could I also like to say, since this trial been going on since June 5th, I've been having nothing but problems with the prosecutor's office. They have never ever gave me any paperwork on this particular case until January 8th, and I had to go downtown to their office to pick it up. I've been calling, leaving messages since November of last year to Miss Rita. She has never ever spoke to me, never. And I can prove that by my phone record. She never called me, never called back.
Now let me ask this question. Do you want to complain to me about Miss Ritter, or do you want to make the victim impact statement?
Well, what I don't want to do is leave my pictures with her. She has never spoke up for me.
You don't? Well, also, okay, I don't want to engage in a victim impact statement, but okay, that's not, those type of things are not my issue, sir. I'm here to hear your victim impact statement. Now, if you want to make a victim impact statement, you can make a victim impact statement. If you want to complain about Ms. Ritter and her not calling you back, you have to go and talk to her. I don't have anything to do with the prosecutor's office.
I spoke to her supervisor. Finally, they
Sir,
called me.
I don't have anything to do with the prosecutor's office. I'm really interested in hearing your victim impact statement. I really want to hear how this has impacted you and what your intent, how do you want the court to move going forward? Do you have any opinion about the sentencing? I don't want you to spend your victim impact statement time complaining to me about the prosecutor's office. I can't do anything about the prosecutor's office. That's nothing I can do about that.
No, I'm only showing up to see if they're gonna be prosecuted for beating me with brass knuckles. I had surgery on my spine years before, and I want to see the outcome. This is why I'm here. I want to see if they're going to be punished the right way or the wrong way. I'm a senior citizen, and to get beaten in a funeral home with some brass knuckles, I'm not going to ever accept that. I have lived longer than I'm going to live, and that's how I feel. This is the most biggest cover-up in the history of anything in Detroit. I had to file
I doubt that this misdemeanor case.
And I got my right. I had to file a complaint against the Detroit detective covering up the coverage in the funeral home. I know smoke when I see it, and I can smell fire. I don't have to speak February 12th or on March 8th, the other two. I don't have to speak then. I came to speak finally today. I'm not gonna come March 8th for the other two. This one here is gonna be setting the pace right here. For the other two, I already know it. I already know it. I've been told by other family members, he's gonna get off the probation because his boss paid off the federal prosecutor office, Kim Worthy. That's right.
So I'm going to interrupt you again because I usually don't interrupt victim impact statements, but I'm borderline getting offended, and I guess I might have to send it to Judge Garrett, because in your statement just now, I don't know if Kim Worthy was bought off or not, but when you say that his sentence is going to be impacted by some money given by Kim Worthy, sir, that implies that I've been bought off. That implies that Kim Worthy has some type of impact on me. That implies that I'm not a person of integrity. And I'm going to set the record straight right now while we're live streaming on YouTube. Don't accuse me of being crooked, sir. I appreciate. Yes, you did. Yes, you. I have asked you. You stood before me, sir, and you've done nothing but complain about the prosecutor's office and the police department. I've asked you to weigh in on the sentencing. I said you could submit paperwork. I've asked you, did you have any opinion about the sentencing? And all you're doing here is standing and complaining about the prosecutor's office and the police department, neither of which I have anything to do with. Neither of which. I don't care what Kim Worthy think about this case. I could care less. I don't care what Chief White thinks of this case. I could care less.
I'm out of here. It ain't over yet.
Judge, you want me to let him go?
Of course he can go. He was never required to be here. Of course he can go.
Understood.
Okay, well, I'm not real sure about that or what's going on with that situation, but I am going to adjourn the case to February the 12th. And let me say this, again, sir, Mr. Mayberry, I don't know you, nor do I know the young man who was just speaking, but I don't know your family. And all I can tell everybody is, don't let nobody get you caught up thinking that I'm gonna do something that I'm not gonna do. Don't let anybody get you caught up thinking that anybody is gonna tell me, other than me, how to do this sentence. Now, I don't know why your uncle is so angry and bitter. It could be because y'all beat him up. Because you are convicted of aggravated assault. But I haven't sentenced you. And I don't know what that was about. But Ms. Ritter, we're going to be clear. And I know Ms. Ritter is clear. But I just want everybody to be clear.
Yes, ma'am.
It can't be paid for. It ain't enough money in the world for that. And I don't know what he's talking about. And I don't know about nothing about Kim Worthy. I don't know. But we're going to do a pre-sentence investigation. And when I read that pre-sentence investigation, I mean, in line, I guess, with the victim impact statement, I don't know. Then Judge Bryant is going to make a determination of what the appropriate sentence would be based upon your criminal history and those type of things. That's the purpose of a pre-sentence investigation. Okay?
No.
You are to have no contact with the complaining witness. And then I'll see everybody on February the 12th at 9 o'clock. And I'm assuming that Mr. Mayberry's presence on the Zoom today indicates that he consents to being sentenced on Zoom and is not demanding an in-person sentencing. Am I correct, Mr. Miller?
Yes, you're correct in that, Judge.
All right, then, unless there's something else for the record, we're all saying anything on behalf of the people?
No, thank you, Your Honor. Thank you.
Anything on behalf of the defense?
No, Your Honor. Thank you. Have a good day and have a good weekend.
All right, you do the same. Everyone have a great day. Stay safe.
Stay safe. Yeah, weather's coming. Mr. Mayberry, we'll be in touch, sir. Okay?
All right.
Ms. Stevenson, I'm ready on. Oh, Parker's in the breakout. Who has let me see. Jackson, I'm ready, or Ms. Shive, I'm sorry. I'm ready on Jackson. Are you ready on Jackson?
Yes, Your Honor.
All right. Alrighty, on Jackson. I mean, where's my officer? Because what's going on here? I'm ready on Jackson. I'm ready on Jackson.
1 second.
Okay, this is case number 234456901. The people of the state of Michigan. Oh, wait a minute. She left. What happened? Now, what I tell y'all when I first came on this Zoom this morning? And y'all have failed twice. Y'all have failed that twice already. Y'all failed twice already. All right. This is case number 234456901. The people of the state of Michigan versus Michelle Eunice Jackson. The defendant is charged with 1 count of disorderly person. Oh, you know what? I should have did. I'm so sorry. The complaining witness on Jackson that's at the podium, have a seat in the chairs to your right, and one of the to your right. Okay, I'm actually going to go ahead and do, I'm going to leave Ms. Jackson on screen though. I'm going to go ahead and do, why is Mr. Hill coming? I'm going to go ahead and do Miss Johnson, Verlinda Johnson. And then I'm also going to do quickly Charlotte Coleman. And then I'll be ready on Jackson. Mr. Hill, while I'm so happy, always a pleasure to see you. Happy New Year.
Happy New Year.
Were you coming on Mayberry? Because someone from your office already came. I did the case.
Yes, they told me that it was adjourned. I just wanted to say hi, Judge. That's all.
Oh, look, I feel so incredibly special right now. But I'm not.
It's been a while. I haven't seen you in a while, Judge, and I miss you.
No, I haven't seen you either. You come over here to my docket.
I know. Next time in the building, I'm gonna come say hi, all right?
Okay.
Okay.
All right.
Take care.
Happy New Year to you.
Have a good weekend. Bye-bye.
All right, you also. Okay, this is case number 234548701, the People versus Verlinda Ann Johnson. Defendant is charged with assault or assault and battery. Today is the date set for pretrial conference. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
Good morning, Your Honor. Jessica Shive, number 81798, on behalf of Ms. Johnson. Ms. Johnson, can you please state your full name for the record?
Verlinda Ann Johnson.
Today is the date set for pretrial conference. How are we proceeding?
Your Honor, respectfully, I believe this is at least the second pretrial date, and I don't believe there's a complaining witness present. I respectfully move to dismiss.
Ms. Ritter?
Judge, this is at least the second scheduling of the pretrial conference. The court required the complaining witness, Ms. Crystalline Messer, to be present. I don't see her in the waiting room, and I don't have an explanation as to why she has not appeared. So at this time, Your Honor, the people will not be able to proceed based on the failure of the complaining witness to appear for the pretrial conference today.
Today is the date set for the pretrial conference. It is at least the second scheduling of the pretrial. The complaining witness was required to appear. They have failed to appear. The people have no explanation for the failure. They are unable to proceed. The court is going to grant defense counsel's motion. The matter is dismissed without prejudice. Ma'am, since you're in the courtroom, you can have a seat and we will get you a copy of an order of dismissal for your records before you leave, okay?
Thank you, Your Honor. Thank you.
All right, you're welcome. Have a great day. Stay safe. All right, Ms. Coleman, start your video, please. Ms. Coleman, start your video, please. I'm going to pass your case.
Good morning.
This is case number 116302401, the people of the state of Michigan versus Charlotte Brenda Coleman. The defendant is charged with one count of assault aggravated, and today is the date set for pretrial conference. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
Jessica Shive on behalf of Ms. Coleman. Ms. Coleman, please state your full name for the record.
Yes, my name is Charlotte Brenda Coleman.
Today is the date set for a pretrial conference. How are we proceeding, Ms. Shive?
Your Honor, I believe this is at least the second scheduled pretrial date. Respectfully move to dismiss. I don't see a complaining witness present.
All right, Ms. Ritter.
Judge, it is at least the second scheduling of the pretrial conference. The court required the complaining witness, Ms. Jasmine Fox, to be present. I don't see Ms. Fox in the waiting room. I don't have an explanation as to why Ms. Fox is not present. At this time, Your Honor, the people will not be able to proceed based on the complaining witness's failure to appear for at least the second scheduling of the pretrial conference.
Today is the day set for pretrial conference. The complaining witness was required to appear. They have failed to appear. The people have no explanation for the failure. They are unable to proceed. The court is going to grant defense counsel's motion and dismiss the matter without prejudice. Ms. Coleman, we will mail you a copy of the order of dismissal for your records, ma'am. Have a great day. Stay safe.
Thank you so much.
You're so welcome.
Okay, Happy New Year. Take care.
Thank you. Happy New Year to you also. All right, I'm ready on Jackson. You can stand back up. Okay, this is case number, I don't know if I called the case, but this is case number 234456901. The people of the state of Michigan versus Michelle Eunice Jackson. Defendant is charged with 1 count of disorderly person. Today is the date set for sentencing. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people. The complainant witness is present in the courtroom in person. Ms. Vincent, state your name for the record, please.
Darla Benson.
And good morning. For the record, Your Honor, Janice Stevenson appearing on behalf of Ms. Michelle Eunice Jackson. Ms. Jackson, ma'am, please tell the judge your full name.
Michelle Eunice Jackson.
Today is the date set for sentencing. Give me 1 second, please. I'm sorry. Okay, I apologize. Today is the date set for sentencing. The court has had an opportunity to review the pre-sentence report. With respect to the pre-sentence report itself, are there any additions, deletions, or corrections on behalf of the people?
Judge, there is one minor correction on the face page, only because I just didn't like how it was put onto the report. So the original charge should be count 1, assault aggravated, count 2, assault or assault and battery. The plea agreement was to dismiss count 1, assault aggravated, and to amend count 2 to disorderly conduct. And that's how we received this final charge. And that plea agreement was a global resolution that was made in the Third Circuit Court with another case in that court.
All right. Okay. Mm-hmm.
And that was it.
Okay, Ms. Stevenson.
Thank you, Your Honor. Ms. Jackson and I have had the opportunity to review the pre-sentence investigation report, and we do offer the following corrections, Your Honor. So on page 6, in the substance abuse use and treatment section, Ms. Jackson, I will just say it like this, Your Honor, in the comments section. Yes, Your Honor.
All right. So, okay, yes. When you say page 6, you mean the page that's numbered 6, because it's not 6 in.
Yes, I do, Your Honor. The page that has the number 6 in the bottom right corner.
Yes. Mm-hmm.
Okay, so the comment section of the substance abuse use and treatment section there, I will say it this way. Ms. Jackson reported during her interview that she was trying to stop using cannabis, smoking marijuana and smoking cigarettes. So she didn't say that, she's advised me that she didn't say that she no longer smokes marijuana. She said that she's trying to stop smoking marijuana and stop smoking cigarettes. And also in that same section, Your Honor, she wants the court to know that she did not report that she consumes 2 to 3 shots of alcohol every 2 weeks. She did report that she last consumed alcohol on November 14, 2023. And at that time, she consumed 2 to 3 shots of alcohol. But her alcohol consumption that she reported is occasional use. Not that she's drinking 2 to 3 shots of alcohol every 2 weeks. Hope that made sense. And then, along those same lines, the page that's printed continued on page 8 at the top left corner. So kind of halfway down that page, there's a sentence that says she reported that she has not smoked since then. And again, Ms. Jackson advised me that that is not what she reported. Other than that, Your Honor, we have no additions, deletions, or corrections. And Ms. Jackson does stand ready for sentencing.
All right. With respect to sentencing, anything on behalf of the defense? Strike that. I'm sorry. On behalf of the people, I apologize.
It's okay, Judge. Yes. So, Judge, the recommendations from the people, because the original charge was assaultive in nature, the people did recommend a term of probation, 24 weeks of anger management, no contact with the complainant witness, and restitution for any out-of-pocket medical expenses that was paid by Ms. Vincent. Looking at the report, Your Honor, on page 2, it looks like there was a recommendation from probation for a 15-month probation period. So I'm asking the court to adopt that. However, they did recommend 15 weeks of anger management. Like the people said, the recommendation was for 24 weeks because of the underlying charge, Judge. So I'm going to ask the court to actually amend the 15 weeks to 24 weeks. And then Ms. Vincent is in person. She did give a victim statement to the probation department, which is on page 4, Judge. However, she is in person, so I would defer to her if she would like to make a verbal victim impact statement to the court since she is in person today.
Okay. Okay, well, hold on. Okay. All right, well, she already said yes, she would like to.
Yes.
Okay, ma'am, go ahead, you may.
Okay, first I would like to thank you, Judge, for allowing me to express my feelings on this case. And I'm going to start off with this. I did not agree to her charges to be dropped down. Me and Christine Ritter had a conversation before that court date. And from my assumption, it was supposed to be that the felony charges was going to get dismissed. And the two charges that she was being charged as in your court case, she said the lower charges was going to be dismissed and she was going to pursue the count 1 of aggravated assault. And the day that the court was, I never was informed about that court case. I was informed about the felony court case. And when I made it over there to their court case, they told me, no, they're in Judge Louise Bryant's court case right now. I said, that's court today? Because they never told me that. So I had to physically run over there to that court. And when I went in there, I kind of didn't understand. I was very confused the day the judge asked me if I agreed to the charges being dropped down. I was like, yeah, because I'm thinking I'm agreeing to the original conversation that me and Christine Ritter had, which was drop the lower charge assault and keep the highest assault. She was charged with 2 counts. I'm thinking she's going to get charged with count 1 and the other assault was going to be dropped. That's not the case. They actually dropped it down to this world.
Yes, I'm hating that I'm interrupting these victim impact statements today. Okay, I'm hating this because I'm confused. Okay. Okay. Okay, go ahead. Maybe it's going somewhere that's going to help me. Maybe it's going somewhere that's going to help me.
Statement. I just wanted to say that because new issues have arisen. So I'm going to go ahead and say my victim statement, but this has to be addressed. It's not that she damaged my shoulder by the torn rotator's cuff. It's more damage that's being done now due to that. And so a disorderly conduct charge is not appropriate as far as I'm concerned. That's not fair to me. She did bodily harm to me. Disorderly conduct is more like if you're being in public, intoxication in public or something like that. It's not the seriousness of my injury should be also the seriousness of the crime. Now, back in March, this is me going to my victim statement. Back in March, it started off in the morning, about maybe 9:30ish, if I can remember, 10 o'clock. The garbage ran. I walked outside my house to plug in the garbage cans. I saw Michelle and her sister Monique outside. I guess Monique carried the garbage cans in. I turned around, I opened up my gate, and I put my garbage can in. I don't know what they were doing. They think that I always watch my cameras. That's not the case. So I went in the house, I washed my hands, I changed to my gym shoes. I asked my fiance, you need something from the gas station? I'm going to walk to the gas station. When I proceeded to walk outside to the gas station, I didn't know at the time, but Michelle Jackson was sitting in her car. Now, keep in mind, she has tinted windows. I pay no attention to them. I don't know where her other sister was, so it looks like nobody was outside. As I'm proceeding to walk to the gas station, she decides to back out her driveway. That's when I realized, she's sitting in her car, back out her driveway and pass me up and go in the direction of the gas station. When I got to the gas station, as walking up to the gas station, she was already parked at the gas station. She was not at a pump or anything, and she had not gotten out of her car yet. She waited for me to go through the doors of the gas station. When I went in the gas station, she came right in, got behind me and started mouthing off at me, threatening me, calling me obscene names. She didn't want to fuck me up, put her hands all in my face, all of that. And so, my reaction, because she was all in my personal space, is I proceeded to put my fingers back in her face too. I said, okay, at this point, I'm gonna call 911. I turned my back to her when I called 911, and she continued on threatening me. I don't give a fuck, this, that, and the other, about me. And some of that should have been called 911 reporting. All I know is while my back was turned, she pushed me enough for me to fall over. And I hit something. That's what damaged my shoulder. I hit something. I don't know if it was the counter or the shelves, but I hit something and I fell over. And she was like, oh, you can't fight me. And she walked out the gas station. And I was really angry. And I'm gonna tell you right now, in the neighborhood, and this is her too, she thinks that a strong person is a bully that likes to fight, can't settle an argument intelligently. But I'm gonna tell you, I'm here to tell you, a strong person is who have endurance, because I have been dealing with a lot and I don't have time. My grandmother a long time ago told me, before she passed off, that in order to keep a person down, you must stay down with them. I'm not trying to stay down with them. I'm trying to elevate. I'm actually decided to move from over there because it's constant. This has been going on for a very long time since they moved over there. It's just been issues after issues with her. Issues with her pulling up in my driveway and just sitting there. This is after conflict arises with our families, that we don't talk, we don't speak, we don't have no association with each other. She would just sit there. That was the issue. Then there was an issue with them pulling up all the way to my driveway, damaging my grass. I've had my property damaged. I've had my cars damaged in the past from her. Tire slashed, scratched up, constant. I've reported all this to the police department. They don't do anything. And then eventually somebody told me in the neighborhood, they have police in their family. So that's why I see that nothing ever happens with them. And her ego has grown to the point where she sat in that driveway and she premeditated this attack, of course, on me. She sat there, she thought about it. She planned to do it because she saw it was going, and she followed me. I'm not gonna say followed me, she made it to the gas station before I did. When I go, because I don't have a vehicle right now, thanks to them, I walk to the gas station. There's nothing else around in our neighborhood but the gas station. It's around the corner. She knew I was going to the gas station, and she decided to beat me there and pass it, and she was in a car. So when I got here, she was already in the parking lot. So she took time out to think about that attack. She attacked me, and then she left. Again, this charge of disorderly conduct, I hope that you can change that. I don't think it's fair when I have injuries, and injuries that I have to deal with for the rest of my life. I had a torn rotator's cuff. I went to therapy, 3 or 4 different therapy appointments. They told me the only way to cure it is to have surgery, but because I am a cigarette smoker and of my age, I'll be 55 this year, this year, and I want peace in my life, that they don't recommend me have surgery. So I decided to go the physical therapy route, and the physical therapy seemed to help. But since then, I've had some more pain. And I said, what's going on? It was trickling down my arms. I was like, what's going on about this? Went back to the doctor, they took x-rays, and they said, oh, arthritis set in. And so what has happened is the rotator's cuff when you have that injury, the cuff is not covering your bone anymore. Your bones are rubbing together. The friction have created the arthritis in my arm. And so now I'm going through arthritis. So every other day I put like a lidocaine patch on my arm. I use a cream and I take medications. And I also been in contact with Ms. McCall, the probation officer, and she told me to email her all this information. And that's what is coming to the restitution part, because I had to go back to the hospital. Now, back when the original incident happened, I had insurance. I don't have insurance anymore. Not that insurance, so I'm not insured. I had to pay to go to the hospital. They actually sending me bills. The hospitals themselves have kind of like, I don't know, they kind of like custom the bill down for me because I'm not insured, but I do still have a balance, and I sent her all that information. And I also have my hospital paperwork from that visit with me today. And so I'm just here to humbly ask you, because I listened to you and you said that, you know, with talking to the last person, that you are a judge of honor, that you don't have anything to do with that. And I'm trusting that you would make the right decision today, because I just feel like the reason all this is going on is because nothing's ever happened to her in the first place. It's giving her a big chip on her shoulder. I don't know, she's a different person right now. That's not who she really is. The light voice, talking, you know, softly and all, no, that's not her. She's embroiled with that gangster lifestyle. She thinks it's cute, you know, coming outside, being out at night, you know, trying to be the baddest one. I don't have time for that. I don't care about that stuff. Neither do I care about what people think, because now, you know, the neighborhood thinks she's beat me down, all that. No, it's not that. And I'm not scared of her either. I'm going to say that. The only reason I chose not to fight her back is because they have police in their family in the past. When I defend myself against any of them, I am the person that gets arrested and go to jail with no question asked, never no charges are stuck, because when they get to court in front of a judge such as yourself, they see there's no relevancy and they dismiss the case. But it's just a problem of going through that, being locked up for 3 days in a Detroit Central Center, paying an attorney money, you know, going through all this stuff. I had pets at my house. This is back before my fiance moved in with me. I was worried about my house, and I forgot to mention 2 summers ago, my front door got set on fire, and I know that she has something to do with that as well. 2 summers ago, there was an issue where she had all these people come on the street, and my children was up. They told me about the next day that they still on the street. They was like sitting outside watching my house. Like, it's been a whole lot of stuff that has happened with this girl right here. And so I feel like at some point she needs to step up and be responsible for what she's done to me. She has not been shown any, she hasn't shown any type of remorse at all. She hasn't apologized, you know, and those charges was dropped down to disorderly conduct. It's like all the care is going towards her. She's not the victim. She caused this to happen. And then they're being so careful about her, like she's delicate when she's not. So I would just like you to reconsider that, because I originally wanted her to be in jail. But they told me that, you know, no, there's no jail time for this. This is a misdemeanor. They also told me that disorderly conduct is the same sentencing as the aggravated assault. So then why she drop the charges down to disorderly conduct? Why not keep aggravated assault on her case? Because she assaulted me. That's what she did, and she caused injury to me. I've never heard of anybody getting injured from somebody from a disorderly conduct case. And so that's what I came to say.
And Judge, I'm sorry.
No, go ahead. It's still
Thank you, Judge. And I just want to clarify a few things, Judge, because I see the way these sentences are going today. Just to clarify, with respect to this case, like I said, Judge, this was a global resolution. There was a felony case in Frank Murphy, and the felony trial APA who handled that case had conversations and negotiation conversations that I wasn't privy to with Ms. Vinson. And Ms. Vinson spoke with him and also spoke with my supervisor regarding this case and about how the plea negotiation will go as far as this case. And just to clarify, Judge, there wasn't any conversations as far as the disorderly person being the same as an aggravated assault. The conversations were that the people would have the recommendations similar to a charge that was assaultive, as the people did clarify in their sentencing record. So I just want to make that clear, Judge.
Okay. Ms. Stevenson, anything on behalf of the defense? No, ma'am. No, ma'am. Ms. Stevenson, anything on behalf of the defense?
Yes, thank you, Your Honor. So I guess I would want to say first that I looked, and I may have overlooked it, but I didn't see the plea recommendation that the people have referenced this morning, that for the term of probation and the restitution. And so I did not advise my client with regard to that. But I did have an opportunity to talk with Ms. Jackson. I had an opportunity to prepare this matter for trial, not being aware at that time that the felony matter was even outstanding and really not even taking it into consideration. And I would say this, Your Honor, just if I know anything, well, I'll start it like this. The incident to which Ms. Jackson has pled guilty did happen at a place where video surveillance was available. So in preparation for, attempting to meet their burden of proof, the people, I believe in this case, as well as in the felony case, took that video evidence into consideration prior to moving toward attempting a global resolution. That is absolutely significant, Your Honor, because I just don't think that if this prosecutor on this docket believed that the global resolution was outside, that it just was not a just resolution, that regardless of what the felony prosecutor wanted to do, if this prosecutor, I believe...
Can I interrupt you? I'm sorry. I'm doing a lot of interrupting today, it looks like, but I mean, your client is literally sitting in the dark and she got her phone up, and I'm getting offended, and I want her to stop. I want her to stop. So she's sitting in the dark. She's on her phone. Ma'am, don't do that to me. I don't know who you think. Let me tell you something. You got the right one today. You have the right one today. So what we can do is adjourn and everybody come in person. That's what we can do. Yeah, because don't do that. Don't do that. Maybe you need to go talk to your client in the breakout room, because don't do that. Because every day that I come on this docket, Lenice Bryant is in control. Lenice Bryant is in charge. I don't care who your cousin is, your brother is, your uncle is, your daddy is. I don't care. You could be the daughter of Barack Obama. I don't care. You in my courtroom.
So, Judge,
now roll your eyes at me again. Roll your neck at me again. And it's going to be different. What I need is for her to find a way to face the sun so that I can see her face.
Okay.
She's making facial expressions. She's on her phone. And she's not being appropriate to this court.
Okay.
So go in the breakout room, get your client together, and come back out and finish making your statement.
Okay. Thank you so much, Your Honor.
You're so welcome. And then I need Miss Shy, maybe, I don't know, I don't want to get y'all business, but I sent Miss Presley to a breakout room, and I can see if I received anything from Miss Presley.
Okay, thank you, Judge.
Yes, Your Honor.
All right. Okay, ma'am, Miss Vincent, I think that's your name. Have a seat again while they go in the breakout room. We're gonna be right back to this case. Oh, they both left. Okay, I was gonna tell them I just sent something on Miss Presley. All right. Ms. Stevenson, before we continue, or both of you, no, Ms. Stevenson, really. Ms. Jackson is in person. What are we doing on Jackson?
Miss Dorothy Jackson. Let's see my note here. I think we're going to set that for a waiver trial, Your Honor.
All right, let's go ahead and do Jackson, and then so she can get going, because this is taking a little longer.
Okay.
And then also tell me, what are we doing on Parker?
Setting waiver trial as well, Your Honor.
Okay, so I'm going to just take a pause for Miss Michelle Jackson. Oh, I said Jackson, but thank you for knowing that I was talking about the other Jackson. And I'm going to put Miss Michelle Jackson in the waiting room briefly, and then we'll set these two dates, okay?
Okay, thank you, Your Honor.
All right. Okay, so I'm first ready on Dorothy Jackson, case number 224537801, the people versus Dorothy Latrice Jackson. The defendant is charged with one count of brandishing a weapon, and today is the date set for final pretrial conference appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
And for the record, Your Honor, Janice Stevenson appearing on behalf of Ms. Dorothy Jackson. Ms. Jackson, ma'am, please tell the judge your full name.
Dorothy Latrice Jackson. Thank you. Ms. Stevenson, before we continue also, did you all see, I forwarded you an email on Presley.
Yes, sir.
Yes, sir.
Okay. All right. So with respect to Ms. Dorothy Jackson, how are we proceeding? Today is the date set for a final pretrial conference.
Yes, Your Honor. And Ms. Jackson is charged with weapons brandishing, and I don't know if the necessary witness was required to be confirmed by today. If that was the case, if that's what the people's recollection is, if that has not happened, I'm going to move for dismissal of this case, Your Honor.
Ms. Ritter.
Your Honor, so the court did set a final pretrial for today's date, requiring the people to confirm the necessary witness for this case. The people's necessary witness was a civilian witness. The people had their OIC reach out to that civilian witness to see if he would be available for trial, Judge. It looks like my OIC confirmed that the witness refuses to prosecute this case. So at this time, Your Honor, the people will not be able to proceed based on the complaining witness's refusal to prosecute.
Ms. Stevenson.
Move for dismissal, Your Honor.
All right, so today's the day set for final pretrial conference, and the court did require the people to confirm their availability to proceed to trial. I don't know if this case has a date, but the people have indicated that their necessary witness refuses to cooperate, and therefore they are unable to proceed. The court is going to grant defense counsel's motion and dismiss the matter without prejudice. Ms. Jackson, have a seat in the courtroom and wait for a copy of the order of dismissal, okay?
Thank you, Your Honor. Happy New Year.
All right, thank you. Happy New Year to you also. Can the person that I let in the courtroom on the Moto G stylist, can you unmute and tell the court your name? There's a person on a Moto G stylist. Can you unmute and tell the court your name? Third time is the charm. This is the final request. Can the person on the Moto G stylist unmute and tell the court your name?
I do apologize, Your Honor. I was hitting unmute. You guys were pushing mute and I was hitting unmute and it wasn't working.
Ma'am, state your name.
My name is Kenya Starks McKinney.
Judge, this is my complaining witness. She was identified earlier. She must have left. I'm going to re-identify her.
On what case?
I'm sorry, Parker, Your Honor.
Oh, well, I guess it's a good thing I let her in. Okay. All right. Ma'am, start your video. This is case number 2144-95101, the people of the state of Michigan versus Shayla Tomei Parker. The defendant is charged with 1 count of assault or assault and battery, and today is the date set for final pretrial conference appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
Janice Stevenson appearing on behalf of Ms. Shayla Parker. Ms. Parker, ma'am, please unmute and say your full name.
Good morning, Shayla Tomei Parker.
And I'm sorry, Your Honor, I have the complaining witness on Zoom this morning. Ms. McKinney, state your full name for the record, please.
My name is Kenya Starks McKinney.
All right, today is the day set for final pretrial conference. Ms. Stevenson, how are we proceeding?
Thank you, Your Honor. Ms. Parker will continue her plea of not guilty. And Your Honor, we do have a jury trial scheduled in this matter for February 12, 2024. Ms. Parker at this time wishes to waive her rights into jury trial, ask that the matter be heard by this court.
No, you don't have a trial scheduled for February 4th.
Oh, I'm sorry. I meant to say February 12th. I'm not sure what I said, but I'm reading February 12th.
Okay. All right, and you said Ms. Parker wishes to do what?
Wishes to have the matter heard at waiver trial, Your Honor. And I'm going to advise the court at this time that I believe, and the people that I believe Ms. Parker to be HIDA eligible with the consent of the people.
HIDA eligible at a waiver trial? What are you talking about?
Yes, Your Honor.
Okay, all right. I'm not going to get into it at this moment. Court is going to continue a not guilty on behalf of Ms. Parker. I need Ms. McKinney to please get stationary. It's very distracting. It's very distracting. We're in court. Come on, people. We're in court. It's 2024. We're coming to court and we're sitting down. This could not possibly be your idea of how to attend court. This could not possibly be. It couldn't be. And I just don't see this on other courts when I'm watching court on TV. Okay. The court is going to continue a not guilty plea on behalf of Ms. Parker. Set the matter or continue the matter to trial. With respect to the trial, Ms. Parker, by her words, your lawyer indicates that you want to give up your right for jury trial and have the matter heard by me. Is that what you want to do?
Yes.
Do you understand that if I accept a waiver from you today, that this matter will be heard only by me? I would be the only decision maker. You would not have a jury to hear your case.
Yes.
Has anyone threatened you in any way, ma'am, or promised you anything to get you to give up your right to a jury trial and have the case heard by me?
No.
Any objection from the people?
No objection, Judge.
Having no objection from the people, finding that the waiver has been made freely, knowingly, and voluntarily, the court accepts the waiver. The matter is currently set for jury trial February 12th. We will move it to a waiver trial for February the actually we could do the waiver trial February the 5th. The waiver trial that was on there is no longer. We could also probably do it February the 8th. Which date do you want?
Defense has no preference, Your Honor. I would ask the court to consider another final pretrial conference before,
Oh, no.
unless the court would leave we could possibly resolve on the waiver trial date otherwise.
I mean, that's up to Ms. Ritter.
Okay.
So I guess I could do a final pretrial the Friday before. That's
Okay. I would appreciate that, Your Honor.
all right. The court's going to set the matter for a waiver trial. And I'm setting my trials at 10:30 now. That
Okay.
12 noon check-in is over unless it's one of them traffic cases.
Okay.
Court will set the waiver trial Monday, February 5th, with the final pretrial Friday, February the 2nd. The final pretrial is at 9:10. The waiver trial is at 10:30. Final pretrial is on Zoom. The waiver trial is in person. Oh, I'm so sorry. There's something in my eye. So please forgive my distraction. With respect to the final pretrial conference, Ms. McKinney, you're not required to appear, but you may appear if you want to. And then if the matter is not resolved and it proceeds to trial, we will be in trial February the 5th. Anything further?
No, thank you, Judge.
Nothing on behalf of Ms. Parker. Thank you very much, Your Honor.
All right, then. We're all set, ladies. Have a great day. Stay safe. Happy New Year to you. All right, I'm ready again on Jackson. Ms. Jackson, start your camera, please. All right. We're back on the record with case number 23-445-7801. All right. No, we're not. That's not the case number, and I do apologize. 234456901. Okay, Ms. Stevenson, you may continue.
Thank you so much, Your Honor. We thank the court for an opportunity to just kind of let things calm down a little bit. So I guess my first observation, Your Honor, and I have had the opportunity, and Ms. Jackson has had the opportunity here with Ms. Vincent has had to say about the incident, but I just don't believe, Your Honor, that regardless of what's happening with the felony case, if the events had transpired in a way more consistent after with what the the victim has testified to, I don't know that the people would have made themselves, the people in this courtroom would have made themselves party to the global resolution, Your Honor, landing us where we are today. I do believe that, you know, review of the video surveillance by the people, in consultation with the victim, Your Honor, led the people to make the offer that they made to not only reduce or dismiss the more serious misdemeanor charges, Your Honor, but to dismiss the felony charge as well. As Ms. Vincent has alluded to, there has been ongoing conflict between these parties, Your Honor. Much of that conflict, Your Honor, resulting in Ms. Vincent receiving, you know, some having been on the receiving end of police contact, Judge. So Ms. Jackson is here to accept responsibility, as she stated in her description of the offense, for being in a public place, at a gas station, getting into this loud argument with the complainant. And she's indicated that that's where it landed. I hate these neighborhood dispute cases, Judge, because it's so hard to just muddle my way as defense counsel through them. But we are where we are, and where we are right now is a disorderly conduct. And that Ms. Jackson has admitted to behavior which is consistent with that charge. And the incident does not happen in a vacuum. Ms. Jackson has been you know, inordinately, in terms of where we are in court, animated, and I believe she's adjusted her behavior. That behavior that you know was not directed at the court, is directed at the volatile situation that we hope has come to an end. I just hope that these people are going to be able to, if they're going to live around each other, that they'll be able to live around each other peacefully. But Ms. Jackson, at this point, Your Honor, does stand convicted of disorderly conduct. And that is after the felony prosecutor and the misdemeanor prosecutor had an opportunity to look at their cases and make a decision as to what the evidence would allow them to be able to prove beyond a reasonable doubt. And they've landed at disorderly conduct. That's behavior that Ms. Jackson has admitted to. And I haven't, again, I don't know if I overlooked it or what, but I didn't see a plea agreement that talked about restitution. So I didn't talk to my client about that, Your Honor, but Ms. Vincent would not be without remedy. She would have an opportunity to present her case in civil proceedings and try at that point to use whatever evidence is available to her to substantiate her claim for restitution. But Ms. Jackson has pled guilty to being in a loud argument with Ms. Vincent, and I believe that the people, based upon their global resolution, agree with that. So I would ask the court to not do restitution at this time, Your Honor. I would ask the court to forgive Ms. Jackson for her behavior this morning, which was earlier this morning, which was really inappropriate. Her frustration is not directed at this court. That frustration is directed at this entire situation. And I think that everybody, including myself, would be able to benefit from some anger management. So I don't think that's going to be harmful to Ms. Jackson in any way. But I would just ask that the sentence, Your Honor, be more in line with the crime to which Ms. Jackson has admitted responsibility. She is working on taking care of these outstanding warrants. I want to address the elephant in the room, that what I believe to be an elephant in the room, that Ms. Jackson doesn't have a driver's license, but the evidence does show that she drove. So the probation department's recommendation that she take the driver improvement class, not drive without a license, that she get a driver's license. I mean, I don't know about the court ordering her to get a driver's license, but certainly we have no objection to any prohibition against driving without a driver's license. And once Ms. Jackson is able to take care of these monetary obligations in Farmington, I think that she'll be on her way. I think all that kind of stems from the same situation, that she'll be able to move toward getting a license. So certainly no driving without a license. I don't know about getting a driver's license. I would ask the court not to do any restitution at this time. Absolutely no objection to no contact between the parties. But I just ask that the sentence follow the charge.
Would Ms. Jackson like to make a statement on her own behalf? Somebody say something. Ms. Stevenson, I'm asking you, would Ms. Jackson like to make a statement on her own behalf?
I apologize for that, Your Honor. I believe that, I didn't see it was that she was muted. I believe that Ms. Jackson would like to address the court. Ms. Jackson, if you could unmute at this time. Go ahead and unmute for us. There you go.
Good morning.
Good morning. And would you like to make a statement at this time, Ms. Jackson?
Yes, I will.
Okay.
Well, I apologize, Judge Bryant. I didn't mean to make you feel disrespected in any way. Me rolling my eyes or anything, I didn't mean for you to feel disrespected. On behalf of my case, Miss Darla, me and Miss Darla, she said we had a back and forth for a long period of time, but it wasn't actually me and Miss Darla having a back and forth. It was her and one of my siblings that she had a back and forth with. The only reason I went up to the gas station that day is because my youngest sibling had already gone to the gas station. Jamal, which is the one that she said that was Monique, the one that she said that was outside with me, but we were never outside together. I was already sitting in my car that day, and Monique just happened to come outside and walk to the gas station. Next thing I know, Miss Darla was walking to the gas station. Now they're the two that been having this ongoing battle back and forth. So I knew that it was going to be a problem at that gas station with them both being there. I only went to the gas station to get Monique in the car, and I wanted to talk to Darla that day. I wanted to talk to her to try to stop some of the drama that's been going on back and forth. That's it. Talking with her did not go well. She, I want to say she's not easy to talk to. So we started arguing. Me putting my hands on somebody. I'm in school trying to be a nurse. I also work two jobs and take care of another person for the state of Michigan. I don't have time to be out here catching cases or doing anything. Yes, I'm 40 years old. This the first time I ever been in any trouble like this. Yes, I do have tickets in Farmington that I need to take care of, but just getting in trouble and arguing and fighting with somebody out on the street, I do not do at all, period. I just wish this never even escalated to this point to where I would have to go through this, but I did. Very, very much so a learning experience. But I never had no bad intentions toward Miss Darla. I always thought she had I know she had an issue with my family. But other than that, I mind my business. The only time she see me is when I'm going in and out the house to work, to school, back. That's the only time she really has seen me. The most she ever talked to me is in a gas station that day. So her stating that it's been an ongoing and that I got tint on my car windows, my car is a fishbowl, Your Honor. You can see right through it. She knew I was sitting there, all that. It's not a car that has tinted windows, period. So I don't know why she said that, but whatever. All I really want is peace. That's it. We stay right across the street from each other. When I walk on my porch, her motion lights to her camera go off. She's watching. She's doing. She even will step out soon as I step out sometimes. So I just want peace. I don't want no more drama after this. This has been life-changing for me to have to go through this. I've never been in court so much in my life. So I just want peace after this. And not only have it's been me and my family, it's all the families around us. All the family down this block has issues and court issues with Miss Darling. But nobody is catching on to who the problem is. I just want peace after this. And that's all I have to say.
That's so
Ms. Ritter, can you address Ms. Stevenson's issue about the restitution? She said she didn't that your plea agreement did not include restitution.
Well, Judge, it was a recommendation based off of the information received from Ms. Benson. I don't have any receipts. I know that the restitution.
I'm saying, address to me why I would order restitution on a disorderly disturbance case, and Ms. Stevenson said it wasn't a part of the proceeding. I mean, wasn't a part of the agreement.
Judge, just stated in the sentencing, there was a recommendation that was similar to the underlying assaultive charge in nature. So that's why the people recommended the restitution, if there was any, for any out-of-pocket medical expenses arising from the underlying charge.
But it's not allowed unless it's an agreement, isn't it? So that is how my question is more to what authority does this court have to order restitution on a disorderly disturbance case unless it was a part of a plea agreement? For a disorderly disturbance case, it's disorderly disturbance. I mean, so Ms. Stevenson is saying she didn't agree to any restitution as a part of this plea.
I understand, Judge, what the court and what Ms. Stevenson is saying. Again, Judge, that was part of the plea agreement for the recommendations.
I still don't understand what you're saying. You keep saying that was a part of the plea agreement, but it wasn't. You saying that's just the people's recommendation.
Correct, Judge.
Oh, okay. Okay, so I'm ready to impose sentence. Mr. Flanagan, I do apologize because, of course, you're aware that I am away from.
Excuse me, Judge, I don't want to interrupt.
But you are, and this is inappropriate. Victims give victim impact statements, and that's it, and that's all. That's
she
it.
lied.
Ma'am, I would hate it. I would hate this to turn a different way. Victim give victim impact statements, and that's it. Now you all are gonna stop. You're not gonna hijack my courtroom ever. Except for the question that I asked at the very beginning, I let you make a statement. It's one of the longest victim impact statements that's been made on the record. And I let you make it because victims have a right to give a victim impact statement. And really, the giving of the victim impact statement in this situation was Grace, because she is charged with disorderly disturbance. According to the Victims' Rights Act, there is no victim on the disorderly disturbance case. But I allow you to make a victim impact statement, and then you're going to interrupt and just hijack my courtroom. This is not appropriate. It's not appropriate. It's just not appropriate. Now I'm ready to impose sentence. Mr. Flanagan, I don't have the form with me, so it may not just be in the order that it normally would be in. All right, so let me say, you know, again, and everyone knows I hate neighbor disputes, because I mean, when you go home, you're supposed to, that's, you know, when you have a hard day at work, when you meet something on the street, you know, strangers, when you encounter situations out and about, when you go home, that's supposed to be your place of rest. That's why you know, domestic violence cases are so serious, and you know, a child abuse case. I mean, children, when they go home, they should be safe. People in relationships, when I go home, I should be safe. And then, but neighbor disputes, they, you know, sometimes they baffle me, because you never have to speak to your neighbor. Like, you never have to ever speak to your neighbor. Like, you literally never have to speak to your neighbor. You can pull in your driveway, or, you know, depending on what side of town you live on, because some neighborhoods, some people don't have driveways. And then you just pull in front of your house and you park, and everybody should understand, like on the streets where there are no driveways, that you're not entitled to the parking space in front of your house. You just are not entitled to the parking space in front of your house. So you have to just park where you can park. And so when you have a neighbor dispute, you know, I wish that mediation could work, because it's better for neighbors who have to live amongst each other to work things out, right? That's what's better. But obviously that doesn't occur in many situations, because of this docket. I've listened to everyone today. I've listened, despite the fact that it is something in the atmosphere that everybody that has come on here almost has been rude and disrespectful to me. And at a certain point, I'm 57 years old. So yeah, I'm 57 years old. And what I didn't do is go to law school, accept an appointment from Governor Granholm, run for election 2 times. I didn't do that and say, ooh, because I love being abused and I love people to disrespect me. And I just want to get up every morning and go to a place where I'm abused and disrespected and mistreated. So it's just amazing to me. Many times, this is my first opportunity to even speak with the people involved in the case. Yet, I'm the person that, you know, people take their frustrations out on. And I guess that is a part of the job. And I've listened to both of you, and both of you have been disrespectful today. I don't know, Ms. Stevenson, the defense made comments about not believing that the people would participate in this type of resolution if the evidence didn't show what Ms. Benson says. I don't know that. I don't know what the people's motives are. I don't know why the people make global resolutions. Many times cases are settled and I disagree. I disagree with the resolution, but that's not my business. That's somebody else's business. I don't know who Ms. Ritter's supervisor knows. That's not my business. I didn't see the video because it was a plea. That's not my business. I don't know. Nobody has shown me the video at this sentencing hearing. So I don't know what the video shows. I don't know who is telling the truth about the video, right? But what I know is that Ms. Jackson stands convicted of disorderly disturbance as a global resolution to cases that started out with felony charges and with a misdemeanor assault aggravated and misdemeanor assault and battery. That's the only thing I know. And then I know that she doesn't have any prior criminal history other than these cases where she keeps allegedly, because I don't know if they're post-conviction or pre-conviction, driving without licenses. All right, so somebody is not being honest because the two stories are opposite. That means when two stories are opposite, that means somebody is not being honest. Well, I can't figure out who's not being honest. This isn't a trial. We're not, ma'am, I need you to stop it. Now, the fact that you're still standing at the podium also.
They have not shown any evidence. No, I'm not gonna keep sitting.
Let me say this, officer, take her into custody. So we're gonna take her into custody right now. We're gonna take her in. Officer,
here. I don't have to
stay
here. I don't.
She's not free to leave. She is not free to leave. She is not free to leave. I am gonna hold her in contempt of court for disrupting and interrupting my proceedings. I am holding you in contempt of court for disrupting and interrupting my proceedings. She is going to have a seat in the jury box and she is not free to leave. She is not free to leave.
I need my jacket.
No, you don't. She's going to sit in the jury box and she is not free to leave. And if you disrupt my proceedings again, the sentence for the contempt is going to include Wayne County Jail. Do not disrupt my proceedings. Okay, now, as I was saying, someone is not being honest, and I don't know who it is. But Ms. Jackson, I can tell you get worked up too. So Ms. Vincent gets all worked up and is rude and disrespectful, and then so are you. And that's probably why you all can't resolve whatever the neighborhood conflict is. I asked you to put your phone down, you rolled your eyes at me. I asked you to turn on to face the sun, or let's try to get, because you in the dark, you was rolling your neck at me. But then when everybody want to talk to me, when you want me to listen to you, when you want me to absorb everything you're saying, then you're nice and respectful. When I'm saying something that you don't like, you're rude and disrespectful. So help me, unpack that. I'm sure when you were in the gas station, nobody was talking nice and calm, like either one of you were talking when you were talking to me uninterrupted. And so your body language says that I don't know why the people gave the resolution that they gave. I don't know. I have no idea why they dismissed the felony cases, why they dismissed it. It could be for a number of reasons, and it could be, if the witness is yelling at you and being rude and disrespectful. But I don't know what goes into their decision making. That's not for me to know. But Ms. Jackson, you came to my courtroom on the day of your sentencing and you were rude and disrespectful. And then everybody is expecting, you expect me to give, the probationary sentence. And let me say this, I learned I was very, I watch a lot of court TV, and a lot of times it's because I'm trying to learn things. I'm trying to learn certain things when I'm watching court TV, right? And there was a judge the other day that got attacked. She was getting ready to impose sentence, and the defendant left all the way across the thing and left all the way across the bench, right? And then he tackled her down. They since charged the young man with attempted murder. And if we were in person, if everybody was in person and not just Miss Vincent, I could see how this situation would have got out of control, and my courtroom would probably be full right now with 2, 3, 4, and 5 officers, because there's not going to ever be a day. There's never going to be a day when I'm going to come to work and not be in charge of my courtroom. And you all have been disrespectful and unruly. But what I learned from the judge, she went to the hospital. The young man almost looked like he was about broke her neck. She was probably very fortunate that when he landed on her, he didn't break her neck. But she came back 3 or 4 days later. And she was careful to make sure that everyone knew and that the record was clear that the sentence that she was getting ready to impose was the same sentence that she was going to impose before that young man attacked her. Now, I use the sentencing and what the victim says and what the defendant says to help me fashion a sentence that is appropriate. When probation gives me a pre-sentence report, it is a recommendation. It is a recommendation. When I hear from the victim, I take that into consideration. I took everything that Ms. Vincent said into consideration. Every single solitary thing. And I'm thinking, this is something, and Ms. Jackson must be a pickle. Until I told Ms. Vincent to stop talking because her term was over. And then, like night and day, Jekyll and Hyde, that switch was flipped. And had I been in person, it probably would have been a different situation. And then she didn't do it one time, she did it twice. So now all of a sudden I'm saying, maybe Miss Jackson, when she gave her calm statement. Now, Miss Jackson gave a calm statement after she had to be sent to the breakout room. She had to be admonished by the court. The problem with this neighborhood dispute, because both of you blaming the other person. This family, they family, this. Well, let me give you both of you a news flash. It's both of y'all. It's everybody involved in the situation. It's nobody has a calm mind to try to resolve conflict. It didn't even make sense that Miss Jackson said she went to that gas station. Excuse me. She went to the gas station thinking that she wanted to talk to Miss Vincent about, the neighborhood. Don't come up to no gas station talking to me while I'm in line to get my items. That didn't even make sense. What made sense is that she saw whoever else she said was walking to that gas station. And she went to the gas station to confront Miss Vincent. I don't need help doing my job. So sometimes, when people agree with me, they try to be the amen corner, they shaking their head and all of this, which is not appropriate in court. But as soon as I say something then that they don't agree with, that now you're rolling your eyes and blurting out in my courtroom like we at the zoo. Well, ma'am, we're not at the zoo. And Judge Bryant is presiding. And if Ms. Vincent wanted to preside, Ms. Vincent should have done the things necessary to preside. If Ms. Jackson wanted to preside, then Ms. Jackson should have done the things necessary to preside. You both have been unruly. So I don't know who's telling the truth. But I'm going to impose this following sentence. And again, what's going to happen is that people are going to stop bringing the prosecutor problems to me. I don't work for the prosecutor. I am a part of the judicial branch of government. If there's any person participating in these proceedings who do not know the separation of the branches of government, there is the legislative branch of government, there is the executive branch of government, and there is the judicial branch of government. And I am a part of the judicial branch of government. I don't work for Kim Worthy, and she does not work for me. Her attorneys do not work for me. I don't make any decisions about who's going to be charged, how they're going to be charged, and when they're going to be charged. I don't make any decisions about what the final charges are going to be unless I am serving in the capacity as the trier of fact, unless I have ruled on a motion. So the displaced anger towards me, because the charges have been lowered, because we've gone from felonies and 1 year misdemeanors down to a disorderly conduct, that is not for the court. That's not my business. That's not my purview. I am going to impose the following sentence. There is a recommendation for 15 months probation, and I'm going to accept the recommendation, but let me tell you something, Ms. Jackson. We don't need angry nurses that's arguing and going up to gas stations and confronting neighbors. And being a nurse is a noble profession. The families that have to deal with nurses, the patients that have to deal with nurses, they're in a situation where they need people that have compassion. They need people that are able to help the family. I just lost a dear friend on yesterday, and she had some of the best nurses that I've ever met in my entire life. And I would be shocked if any of them engaged in the behavior you have engaged in my courtroom today, in the behavior that you're accused of engaging in at the gas station. So we're going to have to change some things. Court's going to set the probation for 15 months. And of course, if you violate the probation and I revoke your probation at some point, just please remember this. Probation is the alternative to jail. Jail is the alternative to probation. I'm currently giving you the alternative to jail. That's probation. If you don't do the probation, jail is the alternative to the probation. 15 months would be 12, 13, 14, 15, April the 10th, wait, what's today? The 12th. April the 11th, Friday, April the 11th. With the following conditions: you shall not violate any criminal law of any governmental unit. You must not leave the state of Michigan without consent of the court. You must report to probation on a monthly basis. And you must notify probation immediately of any change of your address, phone number, or employment status. You will pay the following fines, costs, and fees: $210 mandatory costs, $150 attorney's fee, no, that's not correct. I'm sorry. It's a 15-month probation. Whoops. 300. No, that ain't making sense. I'm doing that wrong. I'm sorry. 15 times. $525 in oversight fees at a rate of $35 per month. A $35 pre-sentence investigation fee. And I am going to order urinalysis once a month, so I'm going to add $150 urinalysis fees. That will be changed at the first review if I'm satisfied with the results. The total fines, costs, and fees. $1,070. Additionally, you shall not use or possess any illegal substances. You shall not use or possess any marijuana without a valid medical marijuana card. You shall not use or possess any opiates without a valid prescription and letter of explanation from the doctor. You shall attend and complete 24 weeks of anger management. You shall have no contact with Darla Vinson. You shall pay any outstanding tickets. According to this, she doesn't have any outstanding tickets. You don't have any at 36 District Court. You shall not drive without a valid license if I didn't already say that. And according to this, your license is not valid. If you get a ticket for driving while you on probation to me, that's violating your probation. So I don't know how you're going to get around until you get a license, but you better not drive. And understand this, your neighbor gonna have a so Ms. Vincent is gonna have a video of you driving. And you just told me your car is a fishbowl. We can see right through it. So you need to go get your license because driving without a license is a violation of the probation. I am going to order the marijuana insight program. You must clear up the warrants that you have in Farmington Hills, Farmington, Michigan, at 47th District Court. And then I'm going to set the matter for review before the halfway point. Let's go with a 4-month review, Jamie Berry. Let's come in May for review, and we're going to go May 10th. For review. At 10 a.m. You must report your probation on a monthly basis, or that's a violation of your probation. Anything further with respect to the sentencing, because then I'm going to address the contempt of court. Anything further with respect to the sentencing?
Not from the people, Judge. Thank you.
Nothing on behalf of Ms. Jackson. Thank you very much, Your Honor.
All right, Ms. Jackson, we are going to mail a copy of this order to the Thornton Street address. Probation is going to contact you at the phone number ended in 2665. You're all set. Have a great day. Stay safe. I need Ms. Vincent at the podium. Ms. Vincent, I don't know if you've ever heard the words direct contempt, but I've held you in direct contempt of this court. You have been no, ma'am, absolutely no, ma'am.
Okay. I'm sorry.
And you keep on talking. You just keep talking. I mean, literally, you keep on talking. I have held you in direct contempt. You have disrupted my proceedings on 2 occasions. Not only did you disrupt the proceedings, when I asked you to stop, you kept going. You overtalked me. You were gonna say what you were gonna say, regardless of what I said. That is rude, it is disrespect, and it is definitely contemptuous. Direct contempt means that you have committed contempt of court in the presence of the court and while court is in session. In case you are not aware, that is punishable by up to 93 days in the Wayne County Jail and up to $500 in fines plus costs, just like what Ms. Jackson was charged with. I don't know what's the situation or why your emotions are that high. And it most certainly would be a shame for Ms. Jackson to not go to jail for what she did to you, but for you to go to jail for what you did to me. Ma'am, if you ever show up in my courtroom ever again, you need to be appropriate. You need to be respectful, because I will lock you up. I will lock you up. So don't do that. I don't even understand it. And I kept asking you to be quiet. And you kept talking over me after I listened to you. After I let you say whatever you wanted to say. After I didn't interrupt you and say your victim impact statement is running too long. Ma'am, I let you talk. And then you just talked all over me and ran all over me. And then, but you wanted me to believe in that same way. You wanted me to believe that at the station, you were calm. You wanted me to believe that you're 55 years old or you're getting ready to be 55 and you don't have time for this. That's what you wanted me to believe. Now, it's hard for me to believe that when you combative and aggressive to the court. And we're literally live on YouTube and literally a multitude of witnesses. My officer is right there. My court clerk is right there. The attorneys are right here. I mean, you literally have a multitude of witnesses, and then you still are combative with the court. But you want me to believe that you were not combative with Ms. Jackson. You want me to believe that it was all Ms. Jackson. I'm going to, with respect to the contempt of court for Ms. Vincent, I'm going to go ahead and hold in abeyance 5 days in the Wayne County Jail. I'm going to hold it in abeyance. So let's be clear. She is in contempt of court. Court is going to hold in abeyance the 5 days in the Wayne County Jail that I would have given her. She's always, as a complaining witness, of course, free to attend any court proceedings. But ma'am, if you attend any court proceedings and you interrupt my proceedings, I'm going to take those 5 days out of abeyance. And you're going to go to jail for 5 days. Am I clear?
Yes, Your Honor.
Okay. You may.
Okay. I apologize. The frustration was not with you. And I know that I had a chance to make my victim impact statement, but she just lied again. And I didn't know that you were
not going to go over that. I'm not going to go over that, ma'am. Victim impact statement is what it is. You make a statement and then you're done. That's it. That's all. It's nothing else. You don't get to rebut what the defendant says. This is her case. She is the defendant. I'm not going to go back over that with you. And then you said it wasn't, your frustration wasn't directed at me. Oh, yes, it was. Yes, it was. You said you ain't listening to my evidence. You ain't doing this. Yes, it was directed directly, ma'am. It was directed directly to me. That's like me yelling at my kids and whooping my kids, or, whipping down my kids, and then saying, well, I'm not mad at y'all. I'm mad at your daddy. Well, then why you in here talking to me? That's what I would say if I was the child. Then why you yelling at me? Then why you raising your voice at me? Then why don't you stop talking? When I'm saying stop talking, okay, I accept your apology. I'm going to not impose the 5 days today. I'm going to hold the 5 days in abeyance. And if you choose to come back, you can. If you don't, you don't have to. And then any other issues with respect to the case and the charging, you can take those up with the prosecutor's office. Have a great day and stay safe. Have a great day and stay safe. Have a great day and stay safe. Officers, we're all set. And y'all need to mute the courtroom, because if she says something going out, she's gonna get those 5 days.